Janet are childhood friends. In her spare time, Janet makes short videos and uploads them on a popular social media app called Glam. Jaden recently came across several of Janet's videos while browsing the app and asked if he could partner with her. During one of their consultative teleconversations, Jaden offers the use of his pick-up truck for any glam-related assignments and general transport needs, while Janet offers up her garage space for their use and as an in-kind contribution. They both agree on a 50-50 ratio on all other expenses. Soon enough, the friends start making money through sales of advertising and promoting content from other users. They do not keep books of accounts and do not pay themselves yet, but they have opened a joint account into which revenue is deposited and expenses settled. Recently, Jerry engaged Jaden and Janet and paid them 1 million Kenya shillings to promote a special night at her club. However, shortly after receiving the money, Janet traveled up-country to take care of her ailing grandmother, and the promotion of the event was not done. Jerry has served Jaden with court papers seeking a refund of her money and costs. A. Explain the most likely form of business association that aligns with the above scenario. Advise Jaden on his liability or otherwise to Jerry. After a long hiatus, Janet has resurfaced and now wishes to formalize her business arrangement with Jaden into an LLC. Briefly explain to Jaden and Janet the effect of the change to their capital base, if any, and any continued liability to Njeri. C. Jaden and Janet indicate to you that the business is just a hustle and that as soon as they finish university studies, they will do away with it. With this in mind, advise them on the better business association vehicle between an LLC and a company and the reasons why.
Thank you for that. Thank you for that. Now, I remember last time we talked about, okay, we were talking about this commercial paper before we began the criminal litigation paper. So we say that this was a bit, okay, compared to, it wasn't a bad paper, but compared to the paper we did, this is a bit trickier. It's not straightforward and clearly needs you to know your stuff when answering these questions. So having that in mind, kindly welcome towards any contribution. So what do you think? What's the most likely form of business association that aligns with the above scenario? What do you guys think? Anyone just a new tender? You don't have one?
I don't have an answer, but I'll go ahead to start off. I was very confused between a private company and a general partnership. Couldn't seem to decide, but guys could.
Nice. Okay. So you've given two options. You've mentioned a general partnership, a GP, or a private company. What else do you guys? What else? No, okay, maybe before we we give somebody else the floor. Why? Okay, tell me why you've narrowed down to the two, a GP and a private company.
So looking into a private company was more focused on the number of partners. No, company does not have the number of members in the company.
Okay.
That's usually 50 for a private company.
Mm-hmm.
And then for a general partnership, it just seemed easier to start it. From my reading, it seems that a general partnership does not really require so much formality. You can start,
Okay.
you can agree to start it either through a written contract or by word of mouth. And then there was also this thing called a joint venture, which I've not really figured out what it is.
Okay, that's fine. That's fine. That's fine. Hi. Now, since you've mentioned and you've brought another concept of joint venture, let's try and now distinguish between all these three, because we're revising. So there's a general partnership, there's a private company, and there's a joint venture structure. Now, you're actually right. All that you've stated is correct. Now, I want us to now distinguish between these three. Then now we come back to the question, and now answer the question and see which is the most appropriate form of business association. Let's start with the general partnership. What is a general partnership? What is it governed? Or what laws govern general partnerships? Begin with that. So a general partnership is basically an association of two or more people who come together with the aim of doing what? With the aim of getting profits. They pool their resources, but it's just a relationship which exists between persons who carry on business with a view of making profit. The key word in this is profit. And the last time we talked about the Partnerships Act. And whenever you find a question talking on GPs or LPs, it's good that you mention the Partnerships Act 2012. Partnerships Act 2012. And then go ahead and define a partnership. It's under section 2. It gives you marks. So explain the most if now we'll come and conclude on which business association is most likely to be in this scenario. But if you're answering that question, you start with saying that a partnership is a relationship that exists between two or more people who come together to make profit. Section 2 of the Partnerships Act defines that. Now, under the Partnerships Act, you have two types of partnerships under the Partnerships Act. There's a general partnerships and there's a limited partnerships. A general partnership is where all the partners have what? Unlimited liability. But a limited partnership is where you have one or more general partners with unlimited liability and one or more registered limited partners with what? Limited liability. So here we have two things. Let's talk about partnerships in general. You have partnerships, the Partnerships Act. You have a general partnerships, you have a general partnership, and you have an unlimited partnership, and sorry, a limited partnership. The difference between these two is general partnerships, all members have unlimited liability. Limited partnerships, you have one or more general partners, each with unlimited liability, and one or more registered limited partners, each with limited liability. That's one way in which you can distinguish between the two. The other way you can distinguish between the two is when, let's say, in the facts, they say there's one person who is hands-on in the business, while another one just contributes maybe money or something. It should automatically click on your mind that that's a limited partnership the question is talking about. The other thing is where each of them are provided for. The general partnerships are provided for under Part 2. Limited partnerships are provided for under Part 3 of the Partnerships Act. The other thing is for general partnerships, it's as rightly pointed out by my colleague who just spoke a few minutes ago, it's less formal. Two people can just meet up, go carry on business, make profit, divide those profits without any formal arrangement, and the law will presume that that's a general partnership. But for limited partnership, the limited partner has to be registered. Now that's just a brief snapshot of what partnerships are. Now from there, let's go to private companies. Where are these provided for? The Companies Act. Companies Act 2015. Now, let's begin. Kindly, what are some of the way I've just summarized general partnerships and limited partnerships? Because we're discussing, and it's a discussion. What are the types of companies? Where are they working? Where they've already stated that one. But let's just start. We have private companies and the Companies Act. What else do we have? We have public companies. Public company. What else? Contribute. What else? Under the Companies Act, limited. Now, under limited days. Unlimited also. Is there anyone we've left out? Now, let's start distinguishing between each and every one of these. So for private companies, restricts the number or limits the number to 50. So you can have only a maximum number of 50 members. That's for private companies. There's also a restriction on transferring your shares. There is a prohibition to members of the public to subscribe to either shares or debentures of the company. And I think that's just it on private companies. Now, for public companies, it's the direct opposite of what private companies are. So there's no restriction on transferring of shares. It doesn't prohibit invitations of the public to subscribe for shares. And what else? Yeah, just the opposite of what a private company is. Now, for limited companies, it can either be limited by shares or it can be limited by what? By guarantee. Where is a company limited by shares? It's limited to the amount unpaid on any shares held by members. Amount unpaid by any shares being held by members. What's the interpretation of that? So let's say an individual holds, let's say 50 shares, but he's only paid for 25 or for 30. The liability will be limited to the unpaid, and the unpaid in that circumstance is 20. That's the interpretation of, it's usually Section 6 of the Companies Act. And then limited by guarantee, this is where the company doesn't have a share capital, and the limitation or the liability is limited to the amount that the members themselves undertake to contribute in the event of liquidation. Now, we're done with that. Let's go to this other one that has been mentioned, joint venture. What's a joint venture? What do you think a joint venture is? I don't have to put legalese, but just what's a joint venture? In simple terms. What do you think a joint venture is?
Alonka, if I may try.
Yes, go on.
I'll try by giving an example. A joint venture is where, for example, I have a land and I want to build some rental houses. Unfortunately, I don't have capital. So I'll enter into an agreement with someone else who has money enough to build rental houses. And that kind of an agreement will be a joint venture, whereby this person will be able to get some profit after the completion of the building, and once the building starts getting some income.
Nice. Okay. Yeah. That's it. So a joint venture is just, for simplicity purposes, it's just a business marriage for a common goal. Meaning, two persons come together. As my colleague just rightly put, you have person A who has maybe the land or the resource, the land resource, but lacks funds to develop that land. And then you have person B who has the funds, but that doesn't have the land. So what can they do? They can enter into a business marriage or a relationship whereby this one brings money, this one brings the land. They set up maybe a hotel, and that arrangement is for running and for managing and for coming up with a hotel. So what do they enter into? It's a joint venture, and they enter into a joint venture agreement. Now, we need to know that there are circumstances where person A and person B are not maybe natural persons, maybe they're legal persons. Maybe this one is a company, this one else is a company. A is a person A with the land is a company, person B is also a company. So there's something known as a special purpose vehicle. Have you heard of it? A special purpose vehicle will be where now they decide, instead of having an informal structure, let's incorporate a company for building this hotel. So you will have A and B. They won't like merge, but they will form a company for purposes of that hotel. Is that making sense? They may form a company, they may form a partnership, they may form, it's the possibilities are endless. Whatever they want to form, they can go on ahead and form. And that will be a special purpose vehicle for that project they are undertaking. Now, like all marriages, you need to have exit options or exit plans. So it's up to you to go read, because it may be tested. What are some of the salient features of a joint venture structure, an SPV? What are there? What is in the contract? What are some of the contractual terms that you may find in a joint venture structure, and so forth? Okay. Now, since you've distinguished all those three, let's now come back to the question. Explain the most likely form of business association that aligns with the scenario. Let's start with that. What is the most likely form of business association now, according to this question? Go on.
Salam. I think a general partnership will fit well. Yes, having said that the same can be initiated without any formalities.
Yes.
And of course, as the question has indicated, the main purpose of the parties is to get profit from the business. So I believe a general partnership fits more better.
Okay, that's absolutely correct. So remember, I can't see you guys. So if you have any contribution, any contradiction, any correction, just unmute and talk. So yes, if I was in the exam situation, I would have said that that's a GP. I would actually have started with saying that that's a partnership. Go ahead and define it pursuant to section 2 of the Partnerships Act. After I am done with that, now come down and narrow down to a GP. Give the reasons why I'm saying it's a GP. And then afterwards, go on ahead and answer the second bit of the question. And the second bit of the question is advise Jaden on his liability or otherwise injury. Now, in general partnerships, we've talked about them having unlimited liability. Now let's talk about what? Yes, please.
Yeah, answer the second part, but I have a question.
You have a? Please go on.
I have agreed on it. General partnership. There are no formality sharing. This is 50, and there's the issue of.
Please increase your voice. Kidogo too. I can't hear you. My volume is up there. Yes. Increase kidogo. Is it me or can you guys hear?
Can you hear me? It's massive.
It's low.
No, it's fine. It's a bit low.
Okay. Yeah. Let me try.
No, it's fine.
Yeah, you said the best option will be a GP because of the various reasons being that it's easy to form no formalities. It can even be in an oral form, as we have seen here. They had a phone conversation. And then there's the issue of sharing expenses at 50-50. And then there was them not paying themselves salaries, which is one of the aspects of GP. But look at line where it says they do not keep books of accounts. And if you read section 16 of the requires keeping books of accounts. What's your position on that?
Okay, now, now the way I can explain this is 16 is a requirement under the law, accounts and partnership records. It's a responsibility of every partner, not the partnership, but every partner should at least keep their books of accounts. But here at the same time, try and look at it this way. How many people out there who are in general partnerships, like informal, let's say in the informal sector, who are engaging in general partnerships, who keep their books of accounts and so forth? It's highly negligible. Even though the law provides for it, it's highly negligible. You may find maybe the guys who are maybe a bit learned, those are the ones who will go on ahead and keep the books of account. I am not contradicting section 16. I agree with it. Every partner has the responsibility of keeping their books of accounts. They need to have the accounting records, and it should be made available. That's true. But at the same time, it goes on. It happens, and that may be a reason why the partnership may enter into future problems. But as it is from the facts, yes, there's a GP. Despite them not having to keep the books of account, it doesn't lock that thing from being a general partnership per se. Yeah, it's not something that will prevent it from being a general partnership.
I agree.
But it's a breach. But it's a breach.
How to express point in case it was pointed out, since it directly contradicts section 16. So I wanted to know how to respond to it in case I have to.
Oh, okay. That's fine. If we bring it, just say that there's a duty. If it's a duty, and the partnership, yes, it's in breach of that duty. I don't know if section 16 has the penal consequences because I don't have it here with me. But yes, it's a breach. But at the same time, it still remains to be a GP without it, despite it not adhering to section 16 of that. That's fine, yes?
Yeah, it's fine. There is no penal consequence in section 16. Maybe if it's coming in later sections, but as it reads, there is no penal sanction for it so far.
Yeah, maybe it's just like a duty for the partners now to, just for accountability purposes. Yeah, things arise in future, disputes arise in future. Yes, and these are some of the things that you will run to. These are some of the things that you will run to, the books of accounts, the records, and so forth when such issues arise in the future. Okay, now let's go on to the second bit of the question. Advise Jaden on his liability or other extrinsic. That's very straightforward. We've said partnerships have unlimited liability. Now somebody expound on that in light of this question. Go on. Advise Jaden on his liability. What's Jaden's liability?
But by virtue of the description that they have unlimited liability, it will then mean that Jaden is liable to Jerry for whatever acts Janet has done.
Yes.
Or rather the failure to meet her responsibility, or whatever part of the contract.
Yes. Now, that's very true.
Can I add also?
Yes, go on. Go on now.
When we talk about unlimited liability, basically this means that partners normally they do not have they have no limit on their responsibility for the debts of the business. This means that that particular partner can lose more than his investment in the business, and if necessary, even he can also lose his personal asset so that they can be able to pay the business debts.
Absolutely true. Absolutely true. That's it. No, that's true. That's true. So you can lose their own personal stuff so as to meet the obligations of that liability. And the provisions for that is it's under Section 22 of the Partnerships Act. If you can see, I noted it down. There are some photos I had sent to you guys on a summary of the Partnerships Act, and it's there somewhere. There, Section 22 on unlimited liability of partners. So the partner has unlimited liability. They are personally liable for any obligation that can be incurred. And in this circumstance, if the court orders that they need to refund, Jerry can go after Jaden, can go after Janet, and each of them will have or will be personally liable to Jerry and to the court orders that have been given to that effect. So the answer to that is Section 22. And I think there's nothing else we've left out on part A. Section 22, you just go ahead and read Section 22 of the Partnerships Act. It talks about unlimited liability, talks about circumstances in which maybe you can avoid that liability. So let's say if at the time the liability was incurred, you are not a member of the partnership, and so forth. Okay, let's go on to the next.
Before we move on,
yes.
What about Section 21, which talks about liability of partnership for loss? Or this is with regards to the whole partnership or not the particular partners?
Kindly read it to me if you have it there, please. Just read it.
A partnership shall not be liable for loss or injury caused by the wrongful act or omission of a partner to a person who is not a partner if the loss or injury caused by a partner, A, acting in the ordinary course of the business of the partnership, or acting with the authority of the partnership.
Okay. So I think that one's coming in to mitigate, okay, maybe to mitigate the harshness of 22. So the partnership is liable. The partnership is liable for any acts of a partner who was acting in the ordinary course of business of partnership or was acting with the authority of the partnership. The partnership generally, it's talking about the partnership. Yeah. Now in this circumstance, let's call the partnership Jaden Janet GP. So Janet Janet GP is liable. The partnership itself is liable. Now the question is going forward and saying, now advise Jaden on his liability. So despite the partnership being liable, what about the individual partners? What's the level of the liability of the individual partners? For Jaden, what's his liability? And that's where now Section 22 comes in. And what does it say? You have personal liability. You have a partner. If you have unlimited liability, you will be personally liable for any judgment order that has been granted against the partnership. Yes. Yes.
I don't think 5 is that kind of liability. What she was talking about, it's talking about non-partners holding themselves as partners of a particular firm. Then they will be held liable by virtue of holding out. But
which section?
Section 25, the one she mentioned, is talking.
No, she mentioned 21.
Yeah, I know you talked about 21, but what the previous speaker talked about.
No, I talked about 22. She talked about 21.
Oh,
yeah, I talked about 21.
Yes.
Then on account of 22, I would suggest maybe adding section 4, which says liability of partners. Each partner in a partnership has unlimited liability. To be a limited to be in a limited partnership, a partner shall have, so general partners is described as unlimited, and for registered partners, registered limited partners is unlimited. So the first part of section 4 is about because it talks about unlimited liability of a partner in a firm. So by virtue of that, then comes section 22. Yeah.
Yes. Yes, okay, section 4 is on unlimited liability. So if it's a GP, we know that all of them have unlimited liability, yes? Now, 22 now says, what's the extent of that limited liability? Now expounds on the limit on that unlimited liability to go on and say that they are personally liable for any obligations, be it judgments, orders, awards, and so forth. 21 now is on the partnership, well, the one that she rightly mentioned, on the partnership itself, the liability of the partnership for acts caused by a partner. And you also brought another one, another crucial one, which is 25, on the concept of holding out. If I'm not wrong, on the concept of holding out, yes. So maybe you can explain the concept of holding out to other members, so that now, since you mentioned it, it's a discussion. I've seen it in several past paper questions. What is holding out in partnerships?
Okay. The concept is that use an example. For example, is Solonka and Patrick Farm, and then I present myself to the public as a partner of that firm, although I'm not, then I'll be held liable for any wrong or any liability that has to be incurred, because the general public has seen me as a partner since I have held myself out as such. So based on that aspect of me holding myself as a partner, I'll be held liable to the liabilities that have to be incurred by the partners in the partnership. That's how I.
Yes. That's basically it. So this is somebody who represents himself as a partner, he'll be liable. Yeah. Okay. Now, so since we've covered that, is it okay now if we move on to the next bit?
A quick one, Mr. Solonka.
Yes.
Is holding out the same as liability by estoppel?
Yeah. It actually makes, yes, it's basically liability by estoppel. And even in some cases, I've read in some case laws whereby even the partnership itself, if it ratifies the acts of that person who's pretending to hold out or who's pretending to be a partner in the firm, then the partnership itself is also going to be held liable. So it's on the doctrine of estoppel and the issues of ratification, such acts. Yes.
Okay, thank you so much.
You're welcome. So you'll be estopped. You're estopped from not claiming that you are a partner if you held out that you are a partner. Thank you for that. Now the next bit is after a long hiatus, Janet has resurfaced and now wishes to formalize her business arrangement with Jaden into an LLP. Briefly explain to Janet, the effect of the change of their capital base, if any, and any continued liability to Jerry. Let's start. What do you think the question wants? Let's help each other out here. What do you think that question wants? Please go on.
I think they want to change the nature of the business from the general partner to an LLP.
Yes, go on.
Yeah, so in that case, I think we'll have to look at the salient features of an LLP, how they are going to do that, how they are going to do the conversion, maybe the registration and the effect of the limitation of their liability business to the people that they owe.
Okay, go on.
Supplying assistance from there.
Thank you very much. That's actually true. So they're just talking about converting their partnership into an LLP. We begin with there. Who else has an additional contradiction?
Solonka, I have a bit of a different view.
Go on.
My thinking will be that I will not go so much into the registration process, but rather I will look at the features of an LLP and how it is different from a general partnership.
Okay.
Yeah, because when you look at the question, they seem to be asking the effect of the change on one, their capital base. So I'll look around that. How does an LLP change what are the features of an LLP as compared to a general partnership, and then go on to the question of liability. Again, what we've just been dealing with earlier, question of limited and unlimited liability, because they're looking at continued liability to injury. So how does it change when this matter goes into when the vehicle is changed to an LLP? My focus will be more around that.
Thank you for that. Thank you for that. Completely sure. Anyone else? Before we start talking about it, you've mentioned LLPs. And now maybe as we go into that, we've talked about GPs, we've talked about LPs, and now this new one has come out, LLPs. So what's an LLP? How different is it from an LP or a GP?
Hi.
Yes.
I'm making reference to the LLP Act in the second schedule, which is also section 4. I will go with that to outline the process of conversion from a partnership to an LLP. That's my first initial thought on how I'd go about the question.
Yeah, please come again. You will go about?
That's how I'd go about it, using section 24 of the LLP Act and the second schedule of the same act.
Yes, 24 is on 24, 25, I think is on conversion. Thank you for that. Section 24, LLP Act. Now we have all those answers, which is absolutely true. So you need to note this question has 8 marks. 8 marks. So how will you go about it? After a long hiatus, Janet has resurfaced and now wishes to formalize her business relation arrangement with Jaden into an LLP. Briefly explain to Jaden and Janet the effect of the changes to their capital base and any continued liability to Jerry. So what all of you guys have talked about is true, and that's how we will approach the question. One, there's the aspect of conversion of the partnership now, as it is, of the partnership.
Solonka, I wish to say something.
Please go on.
We realize that in a simple partnership, the partners have ostensible authority to bind each other jointly, severally. When you come to an LLP, it has a separate legal personality from the individual partners. So my thinking is that before they convert into an LLP, they first of all have to discharge their obligation. They first of all pay injury, because they cannot purport to convert into an LLP, yet they have not paid injury, and then come later and say liabilities were limited. So they first of all have to pay their debts before they can convert into a new business arrangement.
Good observation. Now clearing of the debts.
If I can make a comment.
Yeah, please go on.
The reason why, in my view, they can convert even before paying the debt is that part on change to capital base. So the assets of the partnership will now become the assets of the LLP.
Okay.
Then changes is that their capital contribution is now considered their share in the LLP, such that they retain 50% share, which is not necessarily a change, but it's something different from what they had before. Then the LLP, now that it has the assets, existing assets and existing liabilities, the person, Jerry, can continue the suit against the LLP. And that's under the second schedule, the fifth paragraph. Thank you.
Thank you very much. I was waiting for somebody to mention that thing. second schedule. Actually, it was mentioned by the second schedule. The LP Act. Good. Now, all that you have said is everything that you've said is correct. So it's a very broad question, and you need to bring out all these factors for you to earn your 8 marks. So there's an aspect of conversion of the LLP, but at the same time, you won't just leave it at the conversion bit and then just proceed to the next question. No, you'll have to go on and explain, because they're saying Jared has and now wishes, now wishes. They haven't proceeded yet. Now wishes. So you have to explain to Janet the distinctions between an LLP and a partnership, which you've actually tried clearing. You've actually mentioned some of those distinctions right now. So, but now before we even jump the gun, let's begin with the first one: conversion of a partnership to an LLP. It's under section 24, as rightly pointed out by my colleague, right together with the second schedule. What does it encompass? Maybe somebody who has their act over there. In brief, don't read the entire act verbatim, just try and sift the information and give us the most important bits of it. What does conversion of a partnership to an LLP entail?
Yeah, the change not a statement with the registrar. Really some echo from someone over there.
Let me mute, sorry.
Yeah, they will have to register a statement with the registrar, giving out the details of the new business venture. That is the LLP. It's agreement between the parties, its name, its registered office. So those are the details, the basic details which the statement should contain. And once that is registered, then a conversion would have taken place, as the registrar would have checked and registered the same. Just basically that much.
Thank you. Now that's it. You just make it's a very simple question. You make an application. There's a form, and then after making that application, you have to lodge a statement as has been rightly put out, and then comply with those requirements down there. The proposed name, the nature of the LLP, the offices, the identity, and so forth. Now, after you're done with that, there's that effect. And after you're done with that, obviously registration will happen. Now, what will be the effect of that registration? What will happen? And that's what was rightly pointed out by one of my colleagues here. I can't see the names because it's minimized. But the assets will move to what? To the LLP. Yes, the assets will move to the LLP. Okay, and that comes up, and that brings out something else to this question. Now the assets have moved. The LLP is a body. It's a body corporate. It can be sued. It can sue on its own name. The issue of continued liability injury. How will it change now? Somebody just assist me on that. Somebody tell me how will the liability injury change?
So long as I may comment on that.
Yeah, please.
If you look at the second schedule, I don't know if we read that as sections, but on 13, you'll see that liability. I have not opened it. I just seen it some time back.
Okay.
But I can be trying to open. So if you look at it, it says that liability that had been incurred before the conversion into an LLP still continues. But if the other party had taken the liability alone, then he will be entitled to be indemnified from the partnership itself now.
Please come again. You're saying that a person to that schedule 13, if the liability that was there before will continue going on, but now they can claim from the LLP.
So, for example, you are a partner with me. Okay, we were in a general partnership, and
and I'd done something that brought liability, then I disappeared, and you incurred the liability alone. So if we go into LLP, the liability still persists. But if you had incurred it alone, then the partnership will indemnify you.
Now I get it. Yeah, I get that point. Now, that's absolutely correct. That's correct. Now, you need to check. Somebody maybe open that section 13. Let me read it slowly. So there are two things here. Two things arise. There's Janet. We noted that pursuant to section 22, they are personally what? Personally liable to pay. So if Janet, let's say, discharged that liability, he can claim from the LLP now. But in this question now, in part B, will the LLP be liable? No, there's Janet, there is Jaden, and there is the LLP now itself. Will it be liable? Let me try and open the act here.
Hello, Solomon. Maybe you can read.
Yeah, I think when you read the paragraph 6 of the second schedule as read with section 24, the section 24, 2 and 3, I think the solution to that question is there.
Yes,
as it was rightly put by Mbithi.
Mbithi. There is 6, that's true. I agree with it. By 6, 24, and even 13 talks about it to some extent. So both speakers are actually correct, because if you read 13, partners to continue to be liable, partners to continue to be liable for obligations of partnership before conversion. So despite paragraph 6 to 12, each partner in a partnership that is converted to a limited continues to be personally liable. So in that circumstance, these are all interpreted. If Janet had, let's say, discharged the obligation, then, he has a right to claim from the other partner for contribution, yeah, for that liability. So the other party will still be liable jointly and severally with the LLP. So the LLP will still be liable also. Janet will still be liable and Jaden will still be liable. So it doesn't, all what you guys are saying is correct. Everyone will be liable jointly and severally liable with the LLP. So if you had an obligation, you'd still be liable personally, jointly and severally with the LLP. So yes, that's who's it. Jerry can go on ahead and sue the LLP. Yes, they can sue the LLP, but at the same time, pursuant to 13, they can also go after the partners jointly and severally. That's how we'll interpret that section. And let's say in this circumstance, Janet paid for that amount. Janet paid 1 million. Janet is not liable. Janet is okay. There's a concept of subrogation. What will happen is the LLP will have to fully indemnify Janet. So no one is wrong on that. All of you are correct. Liability will be incurred personally, and the LLP will also be liable. And if the partner had initially discharged that liability, they have the right to be indemnified by the LLP. Now, is that clear now? Does it make sense now?
Yeah, it does.
Okay. Now, what else? What else arises there? Actually, I think we've answered everything, unless there's something we've noted. Now, on the issue of clearing their debts, I haven't seen, or has anyone seen under Schedule 3 the requirement to personally clear the debts? Because I think it will just go on ahead to the LLP. So if they have debts, all what we've been discussing right now will apply. there will be, a debt, there will be an obligation. A debt is an obligation, yes? So there will be that obligation for them to discharge it, and they'll be personally liable jointly and severally with the LLP. So it's not mandatory for you to, it's not a must. If you go on ahead and register it with the debts, my personal take is section 6 all the way to 13 will take effect. So I think we've answered that bit quite sufficiently. And we can go to part 3, part C. Jaden and Janet indicate to you that the partnership is just a hassle and that as soon as they finish university, they will do away with it. With this in mind, advise them on the better business association between an LLP and a company and the reasons why. So basically what they want you to do here is, and I think we've already, so we won't even belabor much on this. They want you to draw a distinction between an LLP and a company. So I just want you to advise them. So you'll maybe just quickly in 2 seconds, 3 seconds, I would even give the answer to that. What's the difference between an LLP and a company? And why is an LLP better from a company? Why is a company better than an LLP, according to you?
I think the first one in the simplicity in the formation of a partnership as compared to that of the company in terms of paperwork.
That's true. Go on. There's like 7 marks there. Anyone else?
I think statutory requirements for a limited liability partnership are less stringent than for company. For example, the filing of returns.
Yes. Yeah, the statutory requirements. Yeah, that's true.
I think in as much as an LLP would be a seemingly better vehicle, when it comes to registration, it's a bit costly, where the LLP, I think it's 25,000 Kenya shillings to register, but for a company, it's only 10,000 Kenya shillings. So in that regard only, I would go for a company in matters how cheap it can be in registration.
Okay. Yeah, that's a good one.
One more. Personally, I will choose an LLP because an LLP is tax transparent as compared to a company.
Okay, expound on that.
In a company, you find that you're being taxed as an individual at the same time the company is being taxed. But in an LLP, it's only being taxed at the individual level. That's it.
Yeah, that's for tax purposes also.
I think the point about outbreak as double taxation in companies, but then in partnership, there's only one point of taxation. And also maybe something else I can also add is the minimum paid up capital. I don't think in an LLP you need a certain amount of minimum paid up capital.
Okay, now, okay. The question is they've put company there, so they haven't distinguished between a private or a public company. But yeah, so if it's a public company, you require minimum paid up capital, but private companies, I don't think they have any minimum required minimum capital requirements. Also, you can actually, since they haven't specified, once you see you've exhausted everything, you can talk about the issues to do with a single member. Please go on.
I think so, another advantage for a company, if you compare LLP and a company on the sources of finance or source of capital, company has shares which will not be there for the LLP. And also on the second thing, on the decision making, probably an LLP must have more than one. That means 2 and above.
Yes.
You see, you have a company, you are the only shareholder, you are the only director. So decision making might be simple in such a company where we only have one shareholder, unlike in LLP where there must be 2 and all of them must agree.
That's very true. Very true. So you have single member private companies. There's a requirement. You can have a single member private company. That's true. Also the mode of borrowing, not borrowing, but raising funds and capital. It's easy in a company because, see, in a company, you're able to give out shares, and shares, that's equity, meaning you're going to bring in capital to the company. So that's it. You've answered the question very well. You've looked at it on both sides. The LLP, the advantages of the LLP, company, and the yes.
You may also want to look at the solution of the two.
Okay, yeah, true. The exit strategy, yes. Which one's easier?
I think the LLP is easier to dissolve. Yeah.
Yeah, sure. You can go check the provisions on dissolution of LLPs and also dissolution of companies or winding up of companies. Thank you for that.
Yes, actually, I thought this statement that is indicating that this Jaden and Janet intend to have the business, they consider it as a hassle and they want to terminate it after university. Is that supposed to lead us to a certain way in that in bringing out the difference between the LLP and company, we are supposed to specifically discuss on the dissolution because that is their main interest, or we are to discuss generally the difference between an LLP and a company, or are we supposed to limit ourselves on the dissolution because that is the main interest? They just want to terminate it immediately after the university.
Oh, okay. Yeah, thank you. I get that. Okay, now, yes, in as much as they want to terminate it, they are looking for other options. I know they've come to you and they're saying, advise us, which is the better business association vehicle, which is the better business. Afterwards, should we do an LLP? Should we do a company? So yes, in as much as they're terminating, they are looking at options, and the options presented are an LLP and a company. So in restricting yourself, you'll find yourself not getting, you may get some marks, but you won't get the full 7 marks. It's better that you look at it broadly. Start with the strongest points, as I said, and then finish down with the points that you think maybe are weak.
So look at my understanding would be that actually the way you have taken it is that I'll look at the 2 parts of the question. One is that it's just a hassle. I think it points us to what you have been discussing: question of formation, question of management, question of tax obligations, and all that.
Yes.
Then now it comes to they intend to dissolve it immediately after campus. Then that's when it points us to the question of how then you'll terminate the relationship or dissolve the entity.
Yes.
Yeah. So I think to me, both sides approaching it that way will earn you like the maximum marks.
Yes, that's true. I don't know what's happening with my screen. I'm seeing something whiteboard. Am I still projecting?
Not really. We're also having it from our sides.
What's happening? How do you move?
But on your screen is, I think something is happening on your screen. You are still projecting, but not the correct content. It's like something is running on your end.
Because I'm not controlling it. I'm I don't know what happened now.
Now,
but
now you're not projecting. You can now put it up. Now you're projecting. Now you can project because it's not off here.
That's fine. That's fine.
Back now.
Sorry. I feel like we've covered part one very well. We've not only looked at the question, but we've gone over and abroad because we even talked about JVs, and I'm sure JVs are in the course already. So let's move on to part two now. The question, part two, question two. Somebody please. Yes.
Before we go to question two, before we go to question two, kindly.
Yes.
The question you asked, and I don't think we responded. You asked what is the difference between an LLP and an LP, of which I feel if you can clarify, I appreciate, because for me, I don't know the difference between these two entities.
Okay. So now the difference between an LLP and an LP is you can see my sticky note. Yes. So let's just talk about GPs. GPs, we said all members have what? All members have unlimited liability. For LPs, you have one or more members with unlimited liability and one or more registered members with limited liability. That's an LP. And then we have an LLP. All members have unlimited liability. Limited, sorry. So that's the simplest distinction between all those three things: a GP, an LP, and an LLP. So for an LLP, you have all members have unlimited liability. For a GP, all members have unlimited liability. For an LLP, all members have unlimited liability. And then for an LP, you have a mixture of both. You have one or more members with limited and unlimited liability, and one or more members with limited liability. That's the distinction between all those three.
Thank you.
Okay, yes.
And LLP
must be
registered.
Yes, LLPs and LPs have to be registered. Any person with limited liability, you see here, you see this keyword here in LPs, registered. They have to be registered. If you have limited liability in an LP, you have to be registered. For an LLP, same, it has to be registered. For a GP, it's not a must for it to be registered. It's just an informal setup, as we talked about. Just a hassle. So hadi hapo tuko sawa, yes?
Perhaps maybe perhaps the governing legislation, they are governed by two. For the GP and the LP, they are governed by the Partnership Act 2012, while the LLP is governed by the LLP Act 2011.
Yes, so GP and LPs, you have the Partnerships Act 2012, and then the other one is an LP. But since you brought it up, let me ask, is there a circumstance where you will have an LLP being governed by an LP? By an LLP being governed by the Partnerships Act? I've never seen such a provision.
Sure. I'm not so sure, but my mind is saying maybe when you're converting an LLP to a LP, I don't know if that's possible. Either the Act provides for such.
Somewhere I read it. Let me see if I can get it.
Also to add on that, Mr.
Section
Salonga.
8 of the LLP Act.
Oh yeah.
Yes.
Imagine it's there. It's usually there. So the Partnerships Act can also apply to it. but insofar as the provisions don't contradict themselves.
Okay, thank you.
A default rule. And actually, since I've mentioned the
Just a
default
small,
rule, go on.
just a small clarification. So it's simply like the, the LSK conditions of sale, like they apply not unless you say they don't apply.
Mm. Yes.
Just a question,
Thank you.
Mr. Solonka. Are there instances where limited liability partnerships can be members to a general partnership in any case?
So the members.
Contradiction itself. It sounds like a contradiction in itself.
Like, can a limited liability partnership operate as a member in any other arrangement like a partnership?
That's a very good question. Okay, trying to think of it.
Bearing that you
So
have
let's start.
kinds of equal personalities.
Yes, let's start with GPs. Can it be in a GP? Answer, everything to do with partnership. That's why I said for you to revise partnerships, you need to just read the Partnerships Act and you'll be okay.
Or rather, it depends with the kind of partnership deed they have.
Yes, I think that will depend with the kind of, not the partnership deed, but also the kind of partnership there is. Because there's a provision in the Partnerships Act, maybe if somebody has, which talks about at least one partner being a natural person. I need to find that one. Then if I get that one, I will most definitely answer your question now.
Okay.
There is that particular provision that talks about natural persons. Who has found it? Maybe to assist.
Is it section 20 of the?
Let's see, 25. In case of a partner who is not a natural person, a document is signed by a partner for the purposes of this section if it is signed by an individual who has authority to sign on behalf of a partnership. So yes, so there are circumstances where you can have legal persons being partners in a GP. There's also another provision. I don't know if it's in the LLL part 3 on LPs. Let me just check. It clearly distinguishes and talks about at least one of them. Or is it in the LLP Act?
Section 9 LLP Act.
Just Section 9 of the LLP Act. Oh yeah, here it is. This is what I was looking for this actually. Who can be partners in an LLP? A natural person or a body corporate can be a partner in an LLP. And a trade union is not a body corporate for the purposes of section. So I think your answer to that will be in the affirmative. I think it will. There will be circumstances where you have an LLP itself being in a GP. I don't know how that relationship will be structured, but it can't be excluded because if we check that 25 that has been pointed out, 25. Here, a document in the case of a partner who is not a natural person. So yes, you can have a partner in a GP who's not a natural person. It doesn't necessarily mean they have to be a natural person. There has to be at least maybe one natural person. So yes, I will answer to that. But at the same time, I will do more research on that and then try and get back to you. Also, anyone can do more. Anyone else can do the same research, and then we can engage on a side chat on that. So, do we proceed to question 2?
I'm wondering if the suggestion maybe explains the relationship that firms have with, foreign firms. Foreign law firms are now having some sort of arrangement. I wonder whether it's the same as one that has been proposed with the local firms.
Okay, foreign law firms and local firms. Now, that's interesting, but now I'd have to check because I haven't come across any, or I haven't read any agreement that they've entered into. Maybe if somebody has access to that, maybe they could get us. Because now, once we read the agreement, we could see the sort of relationship they have based on the agreement that they've made, or the relationship that they've structured pursuant to that merger. So I'd have to do more research on that. Okay, now we can go to question number 2, yes? Someone please read it out.
Jane and Hilda are the directors and equal shareholders of Food Group Limited, a food delivery enterprise. Following a brief decline in demand for the company's services, businesses have since slowed down and the company's liabilities exceed its asset base. Jane is in favor of liquidating the company, whereas Hilda would prefer a period of administration. The company has no secured creditors. So A, on 12th February 2020, Jane issues Hilda a notice to the effect that on 16th February 2020, there will be a directors meeting proposing the voluntary liquidation of the company, and your failure to attend will cause a resolution to be passed in your absence. Hilda seeks your advice on the legality of the said notice. Then B, assuming that the notice in A above is proper, briefly describe the content of the proposed declaration of solvency to accompany the resolution to liquidate the company. Then C, under what conditions would the statutory declaration in B above be rendered ineffectual by law? Then D, Hilda has been able to convince Jane that they should place the company under administration before resorting to liquidation. Advise Jane and Hilda on the primary objectives of the administration of a company and the limitation the law places on directors appointing an administrator. The end.
Thank you. Now let's start with number 1. What's the legality of that notice? What do you guys think?
So long if I'm recommend.
It was gone. I think we did this thing the last time we did commercial. Maybe we did something to this. I think we did something with this regard. Yes, go on.
I don't think the notice is.
Why?
Because the timeline is right, but it was not copied to the holders of the floating charge.
There's a group.
I believe it is usually in section 393 or 394.
It's actually 393. So somebody try and open 393 for us. What? And 393. It's 393. So there are those requirements. I remember we did this thing the last commercial paper we did, it was on, the first question was on the notice. The 3, somebody check, we did it. 3, okay, things to do with liquidation, they start from 390. 391, check, 21, 92, 93, or 4. Yes?
I have a question to the last speaker.
Okay.
He talked about a holder of a floating charge not having been given notice. But there is no mention of a holder of a floating charge. So how does he bring that in? So for me, I wouldn't have thought the notice is not legal. The basis that this is liquidation, and liquidation requires a special resolution. So a special resolution requires 2/3 majority, but only one person is attending to pass this, and that's only half. So it's not reaching the 75%. So thereby, due to lack of the capacity or the quorum required to pass the resolution, the same resolution will be legal, not the issue of floating charge to me. And if the issue of floating charge is right, please explain to me how you bring that in, since it's not appearing in the question.
Okay, now in the question. That's a very good question. Now, somebody tell me, how will you infer holders of floating charge in that question? What's another thing? What's another name for holders of floating charges?
Okay, so long I think both, I would bring in the aspect of the special resolution and also the part of a floating charge. Because if you see in the question, it says that the company's liabilities exceed its asset base.
Meaning
so
have...
that is where now I would bring in the aspect of a floating charge. Yes, it's not expressed, but the fact that liabilities do exceed the asset base, then I would bring it in.
Okay. Okay, let's do this thing actually. Just to repeat, let's repeat this thing again by just checking section 394. Solvency Act.
Alonso, before we repeat,
Go on.
Do holders of a floating charge count as secured creditors? And if they do, the question reads that the company has no secured creditors. So in this context, I don't think the aspect of a notice to a holder of a floating charge would come in.
Okay, thank you for that. Thank you for that. Let's see how they've defined. How have they defined a floating charge? Members of a floating charge or holders of qualifying floating charges under 393.5. For purposes of this section, a person is a holder of a qualifying floating charge in respect of the company's assets if the person holds one or more debentures on the company secured by a qualifying floating charge or the whole by a number of qualifying floating charges that together relate to the whole or substantially of a company secured by charges or other forms of security that together relate to the whole or substantially the whole of the company's property, and at least one of which is a qualifying floating charge. Actually, based on the definition of that, this case, because the question has said they are not secured, I'm inclined towards the two speakers because the company has no secured creditors. So you cannot, based on the definition of a holder of qualifying floating charge, you're not a secured creditor. You have to be a secured creditor. So on the issue of they didn't do it or they didn't give notice to the holders of qualifying floating charges, that one wouldn't because the company has no secured creditors. Maybe there are unsecured creditors, but if you are a holder of a qualifying floating charge, you are a secured creditor. Because the security comprises of all the assets of the company. It floats over the assets of the company. So yeah, that's true. Now, in light of that, how would you nullify the notice? Based on what grounds? So let's just look at it one by one.
Can I?
Yes, please go on.
Okay, for me, looking at the fact, I will because this is like a notice to a director's meeting. So I will go under the Companies Act and not the Insolvency, and look that such a notice should be 7 days notice. And looking from the facts, I think they gave a less notice.
Let me
should
check.
be
Let me
7
check
days.
the question. Directors and equal shareholders limited. On 12th February 2020, Jane issues Hilda a notice to the effect that on the 16th, 20, there will be a directors meeting proposing the voluntary liquidation of the company and your failure to attend will cause a resolution to be passed in your absence. Now, in light of that, please go on again. Come again with that explanation.
So to me, like already, this is like one director giving a notice to the other director that there will be a meeting to do. So it is like a director's meeting. So how do you pass a director's meeting? It should be within 7 days. So I will go to the Companies Act and find where that is. I think it should be 7 days notice.
Just check it. Which section?
Okay, I'm not so certain about the section, but maybe you can just have a look at it, but I'm not so sure. Maybe you can just look at directors' meetings.
Let me try and get it. Resolutions and meetings.
As we look for that, I'd like to supplement.
Please go on.
Subsection.
Subsection?
Liquidation.
Subsection?
393, subsection 393.3. And that's for the Insolvency Act. I'm not making reference to the Companies Act, but it could supplement what the other speaker has said.
393.3. If notice is given a resolution for the voluntary liquidation of a company, such a resolution may be passed only after the expiration of 7 days. I think that's actually it. That's the provision. 393.3 together with the other speaker, what he said about directors' meetings, you can bring those two together. If we get the section from the Companies Act, I'll look for it. But yes, 393. Yes?
If I may interject,
Go on.
393 is talking about notice that was given to the holder of a floating charge, so that after you've given the holder of a floating charge the notice, then the resolution can only be passed after 7 days, not a notice being given to another director.
Okay, let's just read this thing in its entirety. 393, circumstances in which company may be liquidated voluntarily. A company may be liquidated when the period fixed for the duration of the company by the article. Okay, 393.1 just talks about the circumstances in which a company may be liquidated voluntarily. So there are two circumstances where one requires an ordinary resolution and where another requires a special resolution. So an ordinary resolution, so there are circumstances where you can liquidate a company pursuant to an ordinary resolution. And the circumstances where you can do it pursuant to a special resolution. So if it's, let's say for instance, the purposes of the company was made for a specific purpose and that purpose has been done, then you can pass an ordinary resolution to liquidate the company. The other circumstances where, let's say the company was incorporated for a certain duration and that duration has elapsed and come to an end, then you can pass an ordinary resolution to that effect. All other circumstances, you need to pass a special resolution. That's 393.1. So before passing a resolution for voluntary liquidation, the company shall give notice of the resolution to the holders of any qualifying floating charges in respect of the company's property. If notice is given proposing a resolution for the voluntary liquidation of a company, such a resolution may be passed only after the expiry of 7 days from and including the date in which the notice was given, or if the person to whom the notice was given has consented in writing to the passing of the resolution. Now the question is it tied down to holders of qualifying floating charges alone in that? Like statutory interpretation?
Yeah, I think it is.
Before passing.
I'm the one who gave that suggestion. And when you read the section in totality, I think it makes reference to the secured creditors who are, having the qualifying floating charge.
So then I think then based on that, we will have to go to the Companies Act and get that and get our answer, the section now from the Companies Act, because of 394 won't apply in these circumstances based on the reading of the facts, which was pointed out a few minutes ago. So 394 won't apply because 394 applies where the resolution has already been passed and now you want to make a notice. But in this circumstance, there will be a directors meeting proposing the voluntary liquidation of a company, and your failure to attend will cause a resolution to be passed. So the resolution, first of all, hasn't been passed, and it's supposed to be passed in the directors meeting. So Hilda seeks your advice on the legality of the said notice. So here we will just have to look at the two things, ordinary and special resolutions. How do you pass? Actually, the answer to this will be 393.1, if I'm not wrong. I think the answer to this will be 393.1. Because the first bit of the question is saying Jane and Hilda are the directors and equal shareholders of Food Group Limited. So they're the directors and equal shareholders, meaning they're two persons. Meaning they have votes, 50-50. Yes? On 12th February, Jane issues Hilda a notice to the effect that on 16th, there will be a meeting proposing for voluntary liquidation. Now, when I was discussing 393.1, I brought out the distinction between circumstances where you can pass an ordinary resolution and circumstances where you can pass a special resolution. Yes? You remember the way I've distinguished between those two? There are only two circumstances in which an ordinary resolution will be passed. And in these two circumstances, that's where if, let's say, Jane issues that notice, then it will proceed to go on ahead and the resolution can be passed in the absence of Hilda. Because she has, actually she can't pass because you need a simple majority. So it's 50, it's not 50-50, you need 50 plus 1. So you need 51 to pass this resolution. So in the absence of Hilda, Jane cannot pass any resolution to that effect. I don't know if you're in agreement with that. So be it an ordinary, be it a special resolution, you can't liquidate from the facts given here if one member is not there. The legality of the notice of this bit. Your failure to attend will cause this resolution to be passed in your absence.
I tend to incline my thoughts. There is someone who stated that these are notice. You know, before a company holds a meeting, whether with a name to pass a general or a special resolution, there is the requirement as to issuance of a notice, calling or inviting directors and any other person entitled to attend such a meeting. And there are those requirements as to the timelines and the content of that notice. So I feel like this question is specifically on the issues of such a notice. Yes, that's my thoughts.
Now, okay, now, and what would be wrong with that notice then in this circumstance? What's wrong with that notice? Let's start with this. Can a resolution be passed in the absence of Hilda? What's your take on that?
So long as you no.
So now from there,
a special resolution cannot be passed in the absence of Hilda. But I think
even an ordinary resolution.
Yeah, we are going too far because the question is just asking us about the legality of the notice, not of the resolution, of the notice. And this is a 1-mark question. I think we need to focus on the notice.
Now, what would be wrong with that notice? I'm trying to think. What would be wrong with that notice? But still, have they given us timelines here? I think they should be with the timelines. try and open that. The companies, I don't know why it's slipping my mind. It's been long before I went through this thing.
For the company, resolutions at part 8 from section 255.
Yeah, actually, this is the section I was looking for, 287. So first of all, to liquidate a company, so let's just, this is we've got the answer. Now, I think we've gotten the answer. But for us to answer it conclusively, we will have to start with 393.1 and then come about to section 287. So despite it being a 1-mark question, let's start. What resolution is being required, or what type of resolution is going to be required in this circumstance?
So long as look at 393.4.
Agree?
393.4.
Okay. Now, before even going there, okay, I'll go into it just right now. But before going into that, let's ask ourselves, what's the resolution that will be required? Is it a special or an ordinary resolution? To liquidate that. It's a special resolution, yes. Now, what's the timeline that is needed before giving out?
Section 281.
281 all the way to, and this is for general meetings. So this is 21. So I think the issue will be with the timelines. Okay, that's a very tricky. Noah, can you assist on this, Pierre? What's your input on this? Because the issue will be, if I was answering that question in the exam and the way I am, if I am uncertain the way I am right now, I will proceed to give that I will impeach that notice on maybe the timelines and then now go on ahead. Just as a by the way, just in case, I will talk about the issue resolution in the absence of that, in the absence of the other party.
Hello, Solanka.
Because I'm not saying anything else. Yes, go on.
My understanding of the Act is that a general meeting means a meeting convened when required by the directors. And then when it refers to annual general meeting, the Act specifically mentions when it is referring to that. So this
Yes.
281, the notice seems to be 21 days notice if it's a public company, and the same period if it is a private company. But then Part B says 14 days notice in case of any other meeting. So I'm not sure it can be.
So I don't think this is an AGM matter. So I think it's any other meeting. But needless to say, nonetheless, I think this meeting was given, the notice was given on 12th February, and the meeting was to be held on 14th February. So the timeline's there. There's a problem with the timelines. Maybe we could all agree on that.
Yeah, but the section here, 87, is giving us line 3 at least 28 days before the meeting, which I think is the time we are looking for special resolutions, special notice. If I could read, if a provision of this Act requires a special notice to be given, the resolution is not effective unless notice of the intention to move it has been given to the company at least 28 days before the meeting at which it is moved.
Do special resolutions require special notice? Because this is a special, they're talking about special notice, not special resolution.
I tend to believe so, and that's why I had taken you to 393.4, which is now which is now 393.4, which is now taking us to 287. Because 393.4 says the provisions of the Company Act 2015, which deal with resolutions affecting a company's constitution, apply to a resolution under paragraph A of subsection 1 as well as a special resolution under paragraph B of that subsection.
Oh yeah, and they're talking about notice.
Exactly.
But not, is it special?
It would be special because B is talking about what? 393.1B is if, let's go to 393.1B.
Now, okay, let me just open it for you then. Okay, let's hear you first. 391?
393.1B.
Okay.
A company may be liquidated voluntarily. B, if the company resolves by special resolution that it be liquidated voluntarily. Then 393.4 is referring to the Companies Act for purposes of such a resolution and the notice.
Yes.
And so it is taking us to 287.
287. Now, okay, I may be wrong, I may be right, I may be wrong. But now let's look at it this way. 287 is talking about circumstances where the Act says a special notice is given. And the Companies Act and any relating laws provide for circumstances where you don't give out any notice. There are circumstances where you give a special notice. So for instance, one is here, is required, of section 139 of the Companies Act. It expressly states that you need a special notice for a resolution to remove a director under this section. Yes, it expressly provides a special notice. That's one. But if you look at it is here. If a notice is given, proposing as well, okay, not. There's nowhere they've mentioned special notice. They're just talking about a notice has to be given. Is that making sense now? They haven't specified that it's a special notice. They've just said a notice. But there are circumstances where a special notice is needed, and those circumstances are expressly mentioned in the Act. That's where now 287 would apply. So in this circumstance, I wouldn't think 287 would apply because 287 is on requirements for special notice, not special resolution, but special notice of a resolution. Not the special resolution, but a special notice of that resolution. Does that make sense?
Yes, it does.
So one circumstance will be this one here. 139 on the resolution to remove directors from office. Well, the other thing is 1 mark. Let's just come back here. Hilda seeks your advice on the legality of the notice. From this thing, the only way I can impeach the notice would be on two things. And the second one will be maybe overstretching it, as you've said before. The first one is on the timelines. Like from the timelines you've seen so far, this thing is not legal because of short notice. Only 4 days have lapsed. Be it, even if we haven't looked at other provisions, there is no, like 4 days is extremely short for that notice. So that's one way in which I will impeach on the legality of that notice. The other one would be the effect that, okay, the threat that your failure to attend will cause a resolution to be passed in your absence. So just to overstretch it, just to be safe. I don't know who has a contrary opinion or maybe something to contribute on that. But I will start with the strongest point being the timelines for that. Do you proceed now to B? Can you hear me? Okay, now B, we did it last time, so it's expect to maliza haraka haraka. So what are some of the contents of a declaration of solvency? What's a declaration of solvency? Where do we find it? We did it last time. Yes. So declaration of solvency, if you're writing, it's under section 398 of the Insolvency Act. That's 398 of the Insolvency Act. What are the contents of a declaration of solvency? Remember, we went through this the last time we did commercial. The content is simple. Just need to show that as directors, you've made an inquiry into the affairs of a company. And after making that inquiry into the affairs of a company, you are satisfied that the company will be able to pay its debts within a period of 12 months. That's the content. So you just need to stretch it out to get you 2 marks. That the directors have made an affairs into their I've made an inquiry into the affairs of the company, and they are of the opinion that the company can pay its debts within 12 months from the date the liquidation commences. Then you have your 2 marks, section 398 of the Insolvency Act. Now let's move. Yes?
I don't think that's it. I mean, I know that you have, there's a part after you have what it contains, you have to mention the ways in which, or the circumstances in which it will be ineffective. I think
no, that's part B of the question.
Yeah. Oh, that's part C. Sorry, I thought we are already in part
That's
C.
part C, I mean, sorry. No, we are in part B. Part B is just on the simple, I had projected it last time. So that's why I was rushing. We did it last time. So, okay, let me just get it for you. Here, it's in the BRS website, Business Registration Services website. So this is what the declaration of solvency, this is how it looks like. Yeah. So these are the guys. Directors of a company, they just say that they've made an inquiry into the affairs of a company, and they have the opinion that the company will be able to pay its debt within a period of 12 months from the date of commencement of a liquidation. Okay. Then they have to attach their statements of financial positions of a company, the assets and capitals and so forth. That's the declaration of solvency. Now, the second bit of the question is talking about what conditions will the statutory declaration be rendered ineffective? And that's what my colleague was answering. So please go on. What will make it ineffective? Part C. Go on.
Okay.
Just go on then, no problem.
Okay, I think if the resolution, it must be, is it registered within 5 weeks? So if it is not made within 5 weeks, then it becomes ineffective.
Mm-hmm.
And also, if it does not also include those things that you stated up there, like the statements of the company's assets and liabilities, it will be ineffective. Yeah.
Thank you. The answer, I think it's under 398. What?
I think it's 398.
398.
398.2, yes? Yeah. Okay, yes. Now those are the circumstances where it will be rendered ineffective. It is made 5 weeks before. And the ones that he has mentioned. So 398.2. The answer to that is under section 398.2 of the Insolvency Act. And then, since time is rushing, let's see if we can at least complete the paper. Part D, Hilda has been able to convince Jane that they should place the company under administration before resorting to liquidation. advised Jane and Hilda on the primary objective of administration of a company and the limitation the law places on directors appointing an administrator. Okay, let's begin on that. What are the primary objectives of liquidation? And they repeated this question twice because it was also in our question paper, number 1. And they also repeated in the Resit paper. So administration is a concept that you need to familiarize yourself with. So what's the essence of, what's administration in the first place? And what is the essence of administration? What's administration? Have you guys done insolvency?
Yes, we have.
Okay, what's administration?
So I think administration entails appointing a third party to manage the assets of a company. I'm not so sure about the definition, but I'm sure of the objectives. And I think one of the objectives was to maintain the company as a going concern. The second one was to realize the company of the assets of the company. And I think the third one was to pay the creditors, but I stand corrected.
So it's under section 522. 522. Let's open it. Actually correct. That's the answer. You've answered it correctly on the objectives of administration. So 522, maintain the company as a going concern, ensure a better outcome is resorted to than if the company went into liquidation. And then here, to realize the property in order to make a distribution to one or more secured creditors. So 522 is a very crucial section for you to capture, because whenever they test administration, this is what they run to. They run to 522 and 520. And also this other thing about moratoriums when it comes to administration. They usually run to those two things. And we've answered the part on the primary objectives of administration. So let's talk about the issues of appointment of an administrator. So who can appoint an administrator? Here it is. The court can do so, creditors can do so, secured creditors can do so, and the company or its directors. So the question is on what are some of the limitations the law places on a director appointing a company. So what do you guys think? What are some of the limitations? What are some of the limitations?
I think the answer to this is in 544. Yeah, if for example there is 542 to 544, if I'm not wrong, one of the positions would be if there is a moratorium in existence for a company, this moratorium comes to an end, but then there is no voluntary arrangement made. So in such a situation, for the 12 months following such date on which the moratorium has ended, they cannot appoint a director. And then secondly, if the company has a voluntary liquidation, but then it has ended when there is an existence of, if the voluntary arrangement was made during the existence of the moratorium, then 12 months from the date on which the voluntary arrangement has ended, even if it has ended prematurely, they cannot appoint a director. Then another one would be if for example, a company has already appointed a director, then 12 months from the date of on which the appointment of this administrator has ended, they cannot appoint any other administrator. So there's this issue of 12 months in all circumstances having to end after one appointment has stopped.
No, there's nothing to add on that. That's true. So it's found under the restrictions are found under You first read section 541 and then go all the way up to section 544 of the Insolvency Act, and you'll find all those restrictions and the limitations that have been placed on directors when it comes to appointing administrators. Circumstances where, for instance, if there's an application for liquidation, it hasn't been disposed of, and those are the circumstances that are mentioned there. So just go check section 541 all the way to section 544. Thank you for that. Now let's rush and go on to number 3. Somebody please read number 3.
Okay, question 3 or number 3?
Question 3.
Okay, question 3. The Bunge newspaper group has recently revamped its website, which improvement has seen it become a very popular publication in Kenya. The Bunge does not charge for access to the content on its copyright protected website. Udi, a recent college graduate and budding entrepreneur, has also developed and copyrighted his own website, which is built with a software that mines data from other sites. A search of top news items on Udi's site frequently pulls up content from the Bunge's site as well as others. As well as others. Udi's software buries all identifying information from all the sites it pulls content from, even as Udi advertises on his site, thereby profiting handsomely. Faida Bank has recently agreed to finance Udi's operations and wishes to create a registrable interest as a secured creditor. Udi seeks your advice. A. State which interest in Udi's website qualifies for registration and use as collateral under the Movable Property Securities Act. B. Should I proceed to B or we deal? Okay, B.
Yeah, you can proceed.
Okay, so B. Udi tells you that he has recently filed an initial notice under the Movable Property Securities Rights Act, but that Faida Bank has now decided to back out. Advise Udi on the procedure to be followed to effect the cancellation of the notice. That is 4 marks. Then finally, what are the challenges of intellectual property, IP, securitization in Kenya and within the scope of the law? 5 marks.
Okay, now we have the question is on MPSR. So let's begin. Which interest in Udi's website qualifies for registration and use as collateral under the Movable Property Security Rights Act?
Intellectual property copyright.
IP copyrights. I think that's yeah. Yeah, I think that's it. Now, how will we add more oomph into that question? It's defined, yes, under the MPSR. We check section 2, they've defined what an intangible asset is. And intangible assets also form part of movable properties that can be used as security, can be used as collateral. So yes, I think that's copyright IP.
So Lonka, if you look at the there's this aspect of legality. I don't know if you've been feed. And it's not just once, but more than once. They're saying that the site which is copyrighted gets information from other sites, and it doesn't even show that this information, it doesn't even show that this information is from other sites. It projects this information as information produced by Udi himself. So I'm thinking to that extent, since there's some illegality there, do you think it's possible to use an illegal and use under MPSR. What are your thoughts on that? Okay.
That's a very good A search of top news items on Udi's site frequently pulls up content from the Bunge's site as well as others. Udi's software buries all identifying information from the sites it pulls content from, even as Udi advertises on his site, thereby profiting handsomely. Faida Bank has recently agreed to finance Udi's operations and wishes to create a registrable instrument, interest, as a secured creditor. Udi seeks your advice. So the question is, can you use it even if it's engaging in corporate infringement of other, or maybe IP, intellectual property theft of other sites? That's the question, yes?
Yeah. What about that?
Okay.
So
we can discuss that one. Go on.
I think the legal part of it would be under sentence number 4, where we are saying, Udi, a recent college graduate and budding entrepreneur, has also developed and incorporated his own website, which is built with a software, that particular software that mines data from other sites. So the after effect is what is illegal, but the software itself is not illegal. Yeah, all right.
And also, looking at the question, Faida Bank has recently.
Something else. Okay, something else away from, I know it's not really relevant to this question. You also realize that questions of intellectual property are matters of commercial interest, and therefore, short of IP owners claiming against him, there isn't much you can do about it.
That's true. And then also, let's look at the question. The last paragraph is saying Faida Bank has agreed to finance Udi's operations and wishes to create a registrable interest as a secured creditor. Udi seeks your advice. Now, on the question is, part A is, which interest is in Udi's website qualifies for registration? Obviously, that's the intangible. It's the intangible asset being the corporate software. If it's illegal, then that's something that will be determined somewhere else later on. But as it is from the question, they can do that. Now, the issue of corporate infringement, that will maybe now arise in another forum, maybe to try and solve that dispute. So I will still hold on to it unless in the MPSR there's a provision that says you cannot. Which yes.
What's the having a contract which probably would not be enforceable because of illegality, and you are an advocate for these people, and you know what is going on, and you know that there's an infringement, and maybe this bank has advocates who probably advises them on the same. So you've gone through the corporate itself, and you know what the problem is. So you'd still tell the bank to just continue with the agreement, and this issue will be dealt with later if it is brought up. This is what I think. Yes, we can use the copyright, but I think we have to define which part of it are we using. They're telling us that this guy is able to advertise on his site and he gets profits from that. So apart from the news, which of course is getting in a bad way, which is in an illegal way, and that contract, even if signed, would be unenforceable because of that illegality. I mean, who would go at a loss there? The bank, anyway. So since he still advertises on this, I mean, nothing is wrong with advertising, and he's profiting handsomely from advertising. Then I think the only copyright that we can protect is the one, or the money that he makes from advertising, and not the one from the news. And so I think it is proper that we make that distinction.
Oh, wait, no, I get you. But you see, what we're talking about is the copyright to this software. like the software itself?
Solonka. Hello?
Yes, yes.
From my end, if I read the question and the way I understand it, state which interest in UDI's website qualifies for registration. So here, if you look at the facts above, this person has developed and copyrighted his own website. So this website belongs to him and he has copyrighted the same. So he has IP rights over this particular website. So on this aspect of having registered and copyrighted the same, he can, the interest where he can use as collateral, he can actually give ownership of this to the bank. See, and then he will be having a license to operate while the bank takes ownership until this collateral issue and the charge and the loan is settled. Secondly, it's the issue the previous speaker talked about. That is the revenue or the royalties coming in as a result of operating that particular website. So the monies that come in can be actually be used as collateral. So because here what we're being told is qualification for registration and use as collateral. So these two things can actually be used to act as a collateral and be registered under MPSR, because as we are talking of what is it, intangible property, you find that this particular aspect, the ownership of this website, becomes a part and parcel of intangible property, and most the money or the royalty, you can't just say I see the money is ABCD. No, or you know you're getting royalty from it, and it depends on the kind of royalty you're getting. So we can use that, and I don't think the issue of it being the news being illegally obtained, that's not the question. You would address that probably maybe if they had asked you, but since they are seeking you to identify the interests which can be used as collateral, then I don't think we have to deliver and go to all that issue of it being illegal. Unless when we come to question B and they had asked us if the bank advocate, on what grounds would you ask them not to accept such a transaction? Then you can go ahead and claim the legality of the news. But the interests which are securable as collateral here, they're very clear, and I don't think the issue of legality lies in identifying those particular.
Okay. Let's get back to the question.
And plus Solonka, plus you also have to look at the marks awarded to that question. Is actually 1 mark. Is a one-liner answer to me, and I'll move on.
Yes.
I only want to go moralizing around around the question of how the copyright and how the information is being sourced. I will just hang on. What is registrable is that as to where the merit of its registration, it will be a totally different question altogether.
Okay, that's true. Now I get it. I get completely all what you guys are saying. You're saying you're talking. You're all making sense. But now the question is simple. What are we copyrighting? Is it the website, or is it that software that created the website, or the software behind that website? Guys who have done IP.
It is the software.
Exactly.
It's a software that is copyrighted. The software is the creation. That is where the expression is.
Exactly. So the question now is simple. We don't care whether the software is being used to do illegal stuff or engaging in IP infringement, but the software is the intellectual property now, pursuant to the Copyright Act. So from the question, what interest? Sorry, where is it? So can we all agree on that? The thing that is qualifying for registration is the copyright over what? Over that software that is mining the data. Not the data itself, but that software.
So
we agree on that.
If I would like to challenge what you said, the fact that it's the software that is registrable as an interest.
The copyright over that software.
According to Wakimane, okay, the software here is what is copyrighted, but then what interest does this person have in this software? It's the ownership part, you see, or whatever you call it. That's what Wakimani told us. So you don't copyright, you don't give the software as the interest to go and be registered as a collateral. Rather, you give ownership, or you give the royalties or revenue you're collecting. So for me, if I was to answer that question, I would not say the software per se, but I would say the ownership of that copyrighted software, being specific on the interest as ownership, because you're the owner of this part of this particular aspect.
Okay. Now, thank you for that. Now let's look into the law now, yes? So if you check the MPSR, section 2. Unless the context otherwise requires, intellectual property means copyright as defined in section 2. Industrial property, trademark, or any other related right, yes? So you can create a security over tangible or intangible assets, and intangible assets encompasses IP rights. And IP rights, where do you resort to? The various laws that provide for IP rights. So here we have, here we have copyright as defined under section 2.1, also industrial property, trademark, but in this circumstance, we're interested in copyright, yes? So let's look at how they've defined the copyright. Okay? In this act, unless the context otherwise requires acceptable format, let's begin with artistic works. So you can have a security over your painting. Are you having security over the revenue you've collected over that painting, or is it security over that painting itself?
It is security over it is the royalties. What creates the basis for your any copyright, any trademark, any patent, any industrial design to be given as collateral lies in the royalties, the income that it generates.
Yes, I do get that. It's like the whole essence of having IP rights is the revenue that comes from that intellectual, like from the creation of them, and the revenue that comes over it. But what is being given as security? Like what per se is being given as security?
What is given as security is the rights the person has in this particular
exactly.
So that's why I told you, Solonga, you have a right to ownership, you have a right to royalties, you have a right to whatever that is, so long as it's an interest existing in that particular aspect.
Exactly. You have a right over. What is being given is the right over this thing. You've been given a right over the software. You've been given the right over the painting. You've been given the right over the photographs, over the works of architects, all those things that we mentioned over there. The rights over the broadcast, rights over the published edition, rights, basically the rights over that thing. It's not directly on the revenue, but the rights over that thing. So in this question here, what is of interest here? What is of interest here?
So long allow me. If I own a phone and then I tell me the rights I have in this particular phone, what would be my rights? Wouldn't it, if this phone I'm using it to generate revenue, one, apart from me having a right of ownership, what other right do I have? Because if we start from there and can identify the rights, then we'll be able to answer this question. Because I feel you want to disregard the aspect of revenue, and revenue, it's a part and parcel of an interest in anything you own, as long as that particular thing, that particular thing is generating revenue.
Salonka, maybe I would be a breaker at this point, because the two of you are talking about the same thing, in that you are both answering the two parts of the question at the same time. Because from your part, when you're talking about the interest being the copyright, now the tangible document that will go in there.
What is the collateral?
Madam is talking about the collateral in terms of whatever revenues that can be quantified from that particular interest. So I believe that the is fully answered.
Now, what is the collateral in this circumstance?
The collateral now will be, okay, the backing of the interest. The backing of the interest is that copyright on the website and the software. That would be the tangible documents that will be lodged with the bank. And will be registered. But now the quantification of the amounts in terms of collateral are what the person makes, what UDI makes in terms of revenues and royalties. That is what will be quantified, so that also the bank can know how much amount to advance to him on that particular security.
Okay. Let's put it this way. How will you answer that question? Part A. How, just put it in plain words, how you will put it in the exam paper in writing. Which interest qualifies for registration? Yes.
Intellectual property. Right.
Intellectual property, and then you go on ahead.
In copyright for the website and software.
Over what?
Over the proceeds and royalties that come from the particular sale, or from the particular proceeds that he gets from the particular advertisements that are as a result of the software and the copyright. So for me, the parts are: part one, the interest, copyright, and the software. Part two is the revenues that are being generated. So that then the revenues become collateral.
So Lonka, so then you just copyrighted it. You have already secured the whole copyright. Like that's the whole deal. See, that's the copyright under the Copyright Act.
That's the answer now. It's IP, copyright over the software, the royalties. Okay, if you talk about copyright over the software, all rights over the software, revenue, royalties, all those included there. And then you just move on to the next question. Do we now go on to the next question?
Yes, Alonka, we can proceed.
Higher now. Part B is basically how do you effect a cancellation notice? Who has a procedure for that? And where do we find it? Yes, go on.
Salonka, I don't know if you can hear me. One thing that we have to take a note here is that UD tells you that he recently filed an initial notice under the movable property security rights. Now, first of all, you have to realize that it's this same UD who is getting, money from this bank. In a normal circumstance, it's the bank who ought to have registered this and not UD. But be that as it may, he's the one who has registered. I think now it takes us to section 33 of the MPSR Act.
Let me just open it.
Where we have the compulsory registration of an amendment or cancellation notice. Yeah. So I'm thinking it states, if you look at it, this the secured creditor shall register an amendment notice. Okay, that is the first one. There's the one which they talk about. If you just go down a bit, you'll see the one on cancellation. The secured creditor shall register a cancellation notice if the registration of an initial notice was not authorized. Of course, that's not our situation. The registration of initial notice was authorized by the grantor, but the authorization has been withdrawn, and no security agreement has been concluded. I hope you take note of that.
Yes.
No security agreement has been concluded here. Why? Because the bank has pulled out. Now, see, the security right to which the notice relates to has been extinguished, or the secret. So our situation is basically B. There's no security agreement at the end of the day. So because of that, then a registration can be then be registered. And again, if you look at that section, it talks of shall and not may. So it's a must.
Well, that's how you will start now. You need to lay out the statutory, okay, not the statutory, but the substance now, the substantive basis for cancellation notices, as you rightly pointed out. And then now you proceed to give step-by-step processes, and this is found under 13, regulation 13. Here. So, you pointed out 33.5 very well. 33, the section 33 of the MPSR. And now the processes and the procedure, you just find it under, let's look at the subsidiary legislation for the MPSR. So it's important for you to just check this thing. Other than the substantive bit, the ATP is about procedures, so it's good to read the subsidiary legislation of the MPSR, which is under 12, 13, 14. Now, the specific step-by-step processes, you will get it under here. So you request the registrar to register an amendment or cancellation in Form 7. So if you can grasp the forms, fine, that's fine. If you can't, just write the requisite forms, but if you can, the better for you. So Form 7 set out in the first schedule, then the request under shall contain sufficient evidence. Basically, just do it in the prescribed form and then follow these specific procedures. So the answer for that second bit is under Section 33, as rightly pointed out, read together with Rule 13 of the MPSR regulations. General regulations. Legal notice number 121 of 2019. So, up to them. Is that fine?
So look, I have a question. Is there need to really apply to the registrar in this circumstance where we are?
Okay, now you see, actually, check out this thing. How's it called? So this person actually had the right answer. Can you see what they've written here? BRS on e-citizen. So in essence, legally speaking, you just go to legally speaking, they're talking of the registrar, but these things have been automated. So you just go to your e-citizen portal, or to your e-citizen account, and then sign in, and then business registration services. You'll continue, and then collateral registry, MPSR. If you're following, these are the steps. You can now maybe add on to this thing. And then from here, you can now make the amendments, cancellations, and everything. So all these things are automated. So if you make an application under this bit here, you're just making an application to the registrar. It's not that you're making it directly to the registrar, but via this portal, you're making that application to the registrar. Is that okay?
So long, I just had a brief question. If you can just go back to the question, like my issue is, so according to the question, who is, just clarify, I don't know, maybe I'm reading this wrongly. Woody tells you that he has recently registered an initial notice under the MPSR Act, but that FAIDA Bank has now decided to back out. So the initial notice was with the consent of FAIDA. Then
when we are advising UDI, should we tell them that it's Faida Bank that's supposed to start the process of cancellation? Because I don't know. Can you help me understand that bit? Okay, who registered the notice here? Is it UDI alone or UDI and Faida? I am not getting it.
Now, the previous speaker before you spoke actually answered the question. Answered it. What was it? I can see the initial was OD.
It belongs to Daniel.
Now, so who registers it? Hello.
Oh, sorry, I was. Let me know.
Who registers an initial notice?
Okay, in normal circumstances, it's the secured creditor who is supposed to register the initial notice. And that's why when I started answering the question, I made reference to that. In this instance, we have the grantor who, registered this notice. It shouldn't be that way. Actually, it should be the other way. It's the secured creditor who is supposed to register this notice and not UDI. Because if you look at it, at the end of the day, if anything happens, who really wants their rights to be protected? The secured creditor. The grantor really doesn't mind because, who's going to seek remedy at the end of the day? So it's basically the secured creditor who has something to protect. So it's the secured creditor who is supposed to do this. But in this question, it's UDI who did it, and UDI is a grantor. So that's the difference with this question.
No, that's true. So it's two ways. So you register the initial notice. The creditor registers it with authorization of the grantor. But going back to the question, that was just to clear the air out. But going back to the question, advise UDI on the procedure to effect the cancellation. So you don't need to discuss about, from the question, you don't need to discuss about the wrongs that happened or what UDI did and the fact that it was supposed to be Faida Bank that did it. Just go straight and give the procedure under Section 33, read together with the Rule 13. That's how.
Okay, yeah, thank
you. Okay. Now, what are the challenges of IP securitization in Kenya and within the scope of the law? So the first disagreements we had up initially, these are some of the challenges we will bring here. Yeah. So what do you think are some of the challenges when it comes to IP securitization?
Yeah, I'll give a few. I think some of the main one of the main challenges is the question of evaluation of the IP. That while you may banks may begin to use it as security, it is we have not yet established proper IP evaluation systems in the country. Another factor is that certain IPs cannot be the security cannot be dealt with directly. For example, when you talk about copyrights, it requires a process for it to be valued properly and for security to be secured. For example, it may require that there's a trademark license. You license the trademark to be so that it's possible for you to value the trademark and see how much it's making through maybe the license, and therefore the proceeds, the royalties from the license are then what can be used for securitization. But when you come to Kenya, we're yet to really start or properly move into the world of trademark licensing as such. Trademarks are just owned directly by the proprietors, which makes it difficult for it to be directly securitized. When you go to most developed economies, you'll find that a trademark is licensed and actually is not licensed directly by the company, but it's again is a formation of a special purpose vehicle that will then be the one to collect royalties. And then through that, it's easier for you to be able to get collateral from that. What other challenge do we have? It's again like in the same question you have just dealt with. It's a question of IP infringement, that there's the instability of IP in terms of its legitimacy, especially if, for example, in this exact example, a question, the IP might be prone to challenge, to its being challenged for infringement, which will then affect its revenue source and therefore in return affect affect its securitization, because then it becomes the banks will fear using it as a collateral because it is so unstable in a regime where there is no clear regulation of IP use.
Actually, nothing more to add. That was a very open-ended question. I would have had problems getting all the 5 points, but you've raised very good points. So this is just based on how you think and then how you answer. Now go on. Somebody else wants to contribute.
Adding to what he has said, there's also, just apart from just the challenges of valuation of IP, there's also the lack of a standard form of valuation of the IP itself. So that's also an issue. There's also the territorial nature of IP rights. There's also the lack of connection or links between the IP registers and the MPSR registry, which again can cause issues. And then, as one person has mentioned in the chat, there is the lack of uptake of IP there's lack of use of IP to secure funding, and this is also brought about by the lack of awareness of the MPSR itself.
Oh, that's nice. That's nice. Yeah, thank you. Go on.
Okay. Yeah, I wanted to say that just an addition, the previous actually is an authority in this matter, so that's why he was able to actually take us through the same without so many hitches. But I wish to add that the IP laws themselves, they don't give us, they do not provide for collateral. Like you go through the Copyright Act, the Trademarks Act, and you don't see anywhere where they have indicated that they can be used as collateral. And then something else is the MPSR Act is a new statute, so there is that lack of awareness. So like take it for example, if we go to the village and you tell our mothers or even our grandmothers who have a lot of cows, you will find it so hard to convince them that you can use these cows as a security to get a loan. So there's need to be that awareness of the regime, of the MPSR regime, so that it can be applied.
Thank you. Thank you for that. Thank you for that. And maybe since you mentioned
just one addition.
It's fine. Go on.
Yeah, away from what my friend is saying about someone being an authority in the field of IP, there is also the challenge of there being the different IPs actually are regulated by different laws. We have trademarks being the Trademarks Act and the copyright being the Copyright Act, and then we have the Industrial Property Act covering patents and industrial designs and utility models. So you find that they are all scattered in different aspects of law. And sometimes then that becomes difficult when it comes to, for example, even aspects of, to do with, for example, valuation. And then there is no specific law in this country that actually provides for IP valuation itself. They are scattered like that. I think those are a big challenge in itself.
Thank you so much for that. Like I've gained immensely from what you guys are saying. So I think it's getting to 11. Now maybe just to sum it off, you guys have talked about you've talked about so many things that I have gained from. But let's okay. I did IP. We did IP, but it was just a unit that we did in undergrad, very small thing. But what I can remember is IP is broad. When you talk about IP, we have copyrights, we have trademarks, we have patents, industrial designs, and all those things. But now the focus of this question was on, for instance, the part A. I'm answering this in response to the question to the thing that has been posted in one of the WhatsApp groups. So when it comes to IP, copyright, to be specific, you need to think about it this way. When a creditor takes collateral, let's use land for instance. When a creditor takes collateral over a piece of land, it's not commercial, let's say conveyancing. What rights do they have if somebody defaults? What are some of the rights they have? There is the right to sell, yes. There's a right to appoint a receiver, right to... What are some of the rights pursuant to the Land Act? Sell, lease, appoint a receiver. What else? Possess.
Possession.
What else? And all those, yes? Now, when we talk about IP rights, kindly mention some of the IP rights, Like when you say somebody has copyright over software, what are those rights they hold over that software?
They could be holding a license.
Yes?
They could be holding a license over that copyright.
Okay, a license. Now, specifically, what are some of the rights? What are some of the rights they hold over that? What are some of the rights when you talk about rights under copyrights? There's so many rights there, but what are some of the things that you can mention?
Ownership. Are you talking about the right to exclusive use, the right to commercialization, the right to license, the right to assign?
Exactly. So you have rights over royalties. So any royalties and so forth you get, you have rights over, but that's just one. What other rights do you have? Rights to reproduce. You can reproduce those works, yes? If you're a copyright owner.
The right to
adapt. You can create spin-offs. Maybe let's say, for instance, it's a movie. You can create sequels, maybe spin-offs. What else?
If it's a book, you can do editions and all that.
Exactly. You have so many rights. Distributions. You have you have so many bundles of rights inside the IP rights. So in this question, somebody just posted on the WhatsApp group, very, very interesting thing. Actually, somebody posted it. The right to publish, right to reproduce, right to adopt, right to hold, and right to all those. I'll send it to the WhatsApp group. But somebody mentioned, just asked a question. Sorry to take you back to the first question. Someone pointed me to section 22(4) of the Copyright Act. The reading of that section then means copyright will not be an answer in the context. So that's why I opened 22(4) here. And 22(4) is saying a work shall not be ineligible. A work shall not be ineligible. A work shall not be ineligible for copyright by reason that the making of the work or the doing of any act in relation to the work involved an infringement of copyright in some other work. So what does that one mean under section 22(4)? What do you guys think?
No. I think you're getting it wrong.
Somebody asked it on the WhatsApp group. Cancellation.
Yeah, let me answer that. Let me answer that. This is what the infringement will have been. It will, the question will be if the copyright in making that copyright in making the software.
Yes.
This person used somebody's formula, somebody's expression, somebody's with this software. Somebody used somebody else's what do you call it? I'm trying to get the exact word of for me when you're creating these softwares. If someone can come and say no, I have a similar software and this fellow had access to it and therefore copied it.
Yes.
That is when now that you cannot own a copyright in it. But this the software per se
in
this case is not a subject of infringement. The question of infringement is in how then the software is picking data from the data mining.
Exactly.
That becomes a totally separate question. And probably someone will want to even say, perhaps that's why the bank withdrew. Saying no. How stable is this? Because you just you're mining data mining elsewhere and then hiding your tracks and all that. Isn't that an illegality? And then probably that's what scares it off. But the copyright in itself was not an infringement, at least from the facts in the question.
That's the answer to the question. The issue is not about the data. The issue is on the software. How is the software created? The copyright is with the software. He has rights over that software. So the issue is not with the data. The software is being used to infringe, but the way the software was made, there was no infringement in that particular sense. And that is why you will have a copyright over it, and the same can be used as collateral. I hope that answers the question and the group, yes? And then also,
I tend to disagree with you in the sense that, I mean, if we ask ourselves,
please go on. You've unmuted. And then also,
someone has muted me, I think. I don't know why. I was asking, I don't know why someone is doing that. I was asking, when you talk of a copyright, is it the system, the one that you're talking about, and you know how it's mining and you know all that, all those things, or is it the data? What is copyright? I mean, for me, if you talk about the system, that is patent. I mean, that's the idea. That's how they created that thing. But copyright is the end product. What we have.
Somebody stop me.
Someone has muted me again. I don't know why. So copyright is not, it's not the system. Copyright is, you know, what we can see, what we can hear, not the system really. There's a difference between copyright and patent. And I think we are not understanding that difference. My opinion though.
Let me give you the difference. Let me give you the difference about copyright and patent. You don't, when you bring the question of patent, you are starting a totally different subject, because we'll start asking the three requirements and all that. Is it novel, you know, and that kind of thing. Softwares per se are not patents. Softwares per se are mere expressions. They are mere, somebody has mentioned in the chat there, these are just mere codes, expressions, letters, figures, and symbols put together. So in the IP world, softwares in themselves are not patents. At the only point where a software can become a patent is where it comes in to solve something that is novel, something that is new, and it's a technological improvement to something. Those are the aspects. You see, when you look at, for example, the battle that was there between was it Microsoft and some other company there? I'm forgetting the name. You realize that there were aspects of the computer software that were patents, and then there were aspects that were mere expressions. They were mere software that are just a subject of copyright. So differentiate those two. When you talk about and even the question itself has been very specific. They say they have a software which was protected which is copyrighted. That is the product of copyright, that software itself, not anything else. In doing what they were doing, to get no revenue and all that, it's just an aspect of exploitation of the software they have, an aspect of exploitation of their copyright.
Another thing, copyright cannot be registered until it is, put into something that can be read, something that has been expressed. So if it's just a thought in your mind, that's not copyright. But once you reduce it to something that is tangible, something that can be seen, something that can be read, then that is copyright.
Permanent form. We use the word, it must reduce into permanent form.
And
So
I think
noted.
also
Thank you.
section 22 that that is being talked about, is it 20?
Well, who is muting people? Sure.
What
Bro, why are we being muted? So I was just saying that under section 22(4) of the work, it just says that a work shall not be ineligible. So if the question basically stated that, for instance, that this guy, when writing his code, happened to pick a code or a particular set of numbers that is similar to another person's software or similar to the website of this bunge, then you're advising the bank. So it is still going to be eligible to be copyrighted because that is not something that is new. So, and I think also in this whole question, the whole aspect of data being mined and then him passing it off as he's in the website without having any accreditation, then that wouldn't it be even subject to the Data Protection Act? I don't even think it's necessary here. Like, it's not going to be protected under the MPSR or it's going to be protected under the Data Protection Act because you're getting data or you're obtaining data from another website that is, obtained elsewhere, and then your work is to bring it in another. So you basically are obligated under the Data Protection Act to ensure that this data is protected and passed on formally. So I don't think it has anything to do with the Copyright Act in my own 2 cents anyway. Yes.
Now, okay, now to sum it up, this question, is it involved with the data or with the software? Yes, go on.
The software.
I asked the question in the group, and from the reading of section 22.4, I'm not an expert in IP, but I'm thinking that section reads, so assuming the software was built from a certain infringement of another work. So from the reading of section 24, it would then mean you cannot disqualify it only by such reason. Because 24 says, so it would still be eligible for copyright. So
that's the interpretation of 22.4. That's the correct interpretation of 22.4. And then what else? But part of the question is basically on, it's on the software. It's not on. It's not on. Yeah, actually that's true. Let's research. It's not even in the course outline. I agree. But later to confuse what. But the question was on the software, not on the data that was being mined. Okay, copyright over the software. Okay, that's fine. So it's 11 already, and we usually finish at 11. So in the interest of time and also burnout and getting tired, let's look at maybe 4 and then we sum it up. So somebody just read question 4 quickly and then now we sum it up.
Question 4, you recently filed application subsequent to the issuance of statutory demand against one Tom Trudemes Brand House, a registered sole proprietorship. Your client Kazi Kwetu and 20 others are the beneficiary of a court judgment awarding them Kenya shillings 150,000 each as compensation for unlawful termination of employment for a grounds totally for a grand total of Kenya shillings 3.3 million. The blend house is yet to settle the decreed amount, and the attachment efforts by the auctioneer have borne no fruit. Tom has been personally served with the court papers, and you have been made aware that he intends to oppose your application. A, based on the foregoing facts, advise the client on the possible grounds the debtor may rely on to counter your application and how you intend to counter the same. 5 marks. B, the debtor has filed an application for interim orders in response to the bankruptcy application. Advise your client on the grounds to be considered by the court before any interim orders can be granted. 5 marks.
Okay. Realistically speaking, this paper wasn't This was a very challenging paper. I don't need to beat around the bush. It was extremely challenging. Some of these questions need you to have read and really internalized the statutes, not even notes, because there are no notes on this thing actually. Or from the notes that we were taught last year, some of these concepts weren't in the notes. They want you to go and actually read those statutes, Insolvency Act from the word go, and internalize it. So what do you think? What are some of the grounds you can advise your client to counter that application? Because you know, when you make a bankruptcy application, you know those requirements. There's a creditor's application, there's a debtor's application. Now this is the creditor's application. There are certain requirements that you need to comply with. Maybe we can begin with that. What do you need to comply with when you're making a debtor's application? A creditor's application, sorry. What do you guys think? So, okay, let's just move quick. What you do is, when making a creditor's application, the answers, everything to do with creditor's applications is found under section 17 to 31 of the Insolvency Act. Yeah? And you just make an application in the insolvency regulations, and that application is to be followed by various documentation. That is, you need to have a verifying affidavit, you need to have a proof of debt, you need to have the application for appointment of a bankruptcy trustee, and then also the petition. But you also need to send a statutory demand, which is crucial. So, somebody impress me and think outside the box. How will you counter? This person has admitted that they didn't send a statutory demand. How can you counter that? How can you counter that? That's what, and it's a very small provision, a very slight provision in the Insolvency Act. I've given you the leakage now. How do you counter? How will you counter that application? So we said it starts from section 17 to 31. So in between section 17 to 31, there's a way in which you can counter. Has anyone found it?
Is it
Section
19?
Yes, on expedited. Is it on expedited procedure? Expedited. Yeah, they call it expedited. Expedited creditors application. Who said the answer? Yeah. Okay, it is. If a creditor's application is made wholly or partially in respect of a debt that is subject of a statutory demand, the application may be made before the end of the 21-day period referred to it if there is a serious possibility that the debtor's property or the value of any of that property will be significantly reduced during that period, and the application contains a statement to that effect. I think that's how I will approach the question, unless somebody has an additional, a contrary opinion or a contrary view. Because in essence, what happens is, before you can bring an application, you have to send a statutory demand and you have to wait for 21 days to lapse. After the 21 days have lapsed, now you can bring the application. But in this circumstance, they're saying that in this circumstance, they are saying that this person did not issue the statutory demand. So this other guy wants to bring an application to counter. So how would you assist your client? I will rely on 19. Anyone has a contrary view? Maybe this paper was pretty wide. So how would you do it? to you? Or do you agree with the way I would have approached it?
I agree.
Okay, then I think that would be the basis of the answer. Section 19, in short, expedited procedure, and you will try and argue and give the grounds that the assets will, that the assets of the property will significantly drop during that period, and then argue other things, proof of debt, this person is truly indebted, things of the sort, and then now just to add on to make sure you get the 5 marks. So I will throw in section 19 over there. So maybe in your own time, you could check case laws to that effect to determine what other grounds you can adduce. So A is on section 19, expedited procedure. B, the debtor has filed an application for interim orders in response to the bankruptcy application. Advise your client on the grounds to be considered by the court before any interim orders can be granted. Debtor has filed for interim orders. Okay, go on. Somebody, please assist on that.
So if I may attempt.
Go on.
I'm not sure. I think one of the things that the court will consider before issuance of the interim orders is whether there was a service or there was any proper service of the notice of the demand. Is it the demand notice? Yeah. So I think that is the thing that the court will consider before issuing these interim orders. So I start guiding.
That makes sense, but there's a specific section I'm trying to get on those interim orders. Okay, let me just read the question again. The 306. We'll go to the. Okay, let's first let me get the question. Has filed an application for interim orders in response to the bankruptcy application. Advise your client on the grounds to be considered before any interim orders. Okay, they haven't specified what interim orders he was seeking for. That's the problem with that question. What kind of you cannot just say interim orders. What kind of interim orders was seeking for?
I think the answer can be section 3 note talks about an application to out for interim order made if the debtor intends to make a proposal to the creditors on the giving out a composition for satisfaction of the debt, and such application, he should have mentioned the supervisor of such an arrangement. There is no.
Surely, somebody muted her. She's the one who's actually pointed to the answer.
She's been removed actually. Okay.
We'll crack down on these people. Yes?
Sorry, someone keeps removing me from meeting. That's why I stopped talking earlier.
Sorry.
I give up. But 304, you can find the issue on interim orders and the powers of the court in regards to the same, and the 306.
That's actually the correct thing. So I was thinking along the lines of proposals, summary installments, or voluntary arrangement. There are 3 things. There's the no asset procedure. There is a proposal or summary. Okay, what are the alternatives to bankruptcy? We have the no asset procedure. What else? Voluntary arrangement. What else? Summary installment. Yes, those are the 3 things. Now, 306, when you're making a proposal, and I think that will be, the proposal is actually broad. whereby I think that will fall under the installment orders or summary installments or maybe voluntary arrangements, if I'm not wrong. But I'll do research on that and then get back to you. It's been long since I interacted with this thing, but I'll do research on the same and then get back to you. But as it is, you'll go check section 306, as has been rightly pointed out by my colleague who just spoke right now, read together with 304, and then read together with, 304, 306. If you've made a proposal, if those nitty-gritties inside that section. And a supervisor. So you need to distinguish between these concepts. You have a supervisor, you have an administrator, you have a receiver. You can also check receiver manager, the ones that are applicable in the previous insolvency laws, and so forth. They bring those things in the exam. So I think it's 11:30. Maybe we can finish off these two other questions next week. But have you seen the way commercial, can be twisted and twisted and twisted? That's why your biggest friends should be the statutes and the regulations. This paper, in as much as it wasn't a bad paper, it was a very tricky and challenging paper because the thing to do with, for instance, let's check number 4. The thing to do with the expedited procedure, that's not something that was taught. I actually learned about the expedited procedure when I was reading the Insolvency Act some times back. But it's not something that was mentioned in class, and it's not something that was taught by the lecturers. So you have to go the extra step and at least summarize these statutes and look at the most pertinent and most crucial sections when you're going and reading for units such as commercial, conveyancing, and all those. So up to there, I hope you're okay. I hope you've gained. I think we've covered a lot. And I hope it was a fruitful exercise tonight. Now, I don't know if Noah is still in or he retired. No, I think he's retired. So maybe we can close it up unless somebody has a question. It was a tricky question, but I'm glad we managed. We engaged, I gained new insights, and I hope you've gained also. The paper was a complete madassin. That paper was bad. It was a bad paper compared to the paper that we did last year for the main exams. It was a fairly bad paper. It was an extremely bad paper. And the ironical thing is many people dropped out of the commercial paper that we did for the main exams, thinking that it would be bad. And then they brought the bad paper they actually brought the tricky paper on but the chat box has been activated. They brought it later on subsequently. So the question for number 4B1 was section 306 read with section 304. Yeah, because I remember for us we were told, what's the distinction between a franchise and a joint venture structure? Those are the questions we were brought. And then here somebody brings something to do with expedited procedure, the procedure for cancellation notices. I actually didn't think they can bring such questions up to date, but all the best, you'll manage. Try and pass the exams on the first go, because from my experience, receipts, they aren't always good. So try and do it from the first go. So guys, unless you have a question, I want to wish you a good night and have a happy and lovely week ahead.
Good night.
Okay.
Thank you,
Solonka.
Yes, Mkambe.
Can you assist me with the provisions on expedited procedure?
Okay, you will check section 19 and then read together with the insolvency regulations. But the substantive bit is section 19 of the Insolvency Act. Then I'll try and pair it up with the insolvency regulations on the specific processes. Okay.
The lovely, the week which will go up to Monday, yeah?
There?
The lovely bit of your wishes should go until Monday, not just end in the weekend.
Okay, up to Monday and then subsequent week up to when we finish your exams. Okay, guys, have a lovely night.
Good night.
You too.
Good night.